second and final panel. It's entitled Litigation Perspective, Courtroom Strategies, Potential Outcomes. Again, I'm Nate Soderstrom, Senior Editor at the Capitol Forum. Joining me today, closest to me first, Corey Rausch is a partner at Aiken Gump, where he leads the firm's antitrust and competition practice. Corey represents clients in federal antitrust, consumer protection, and key TAM investigations and litigation in district and appellate courts around the country. He's also represented clients before the FTC, DOJ, and various attorneys general, and has litigated multiple merger trials against the government, including both the FTC and DOJ. Most recently, he served as lead trial counsel for Wilhelmsen Maritime, the FTC's 2018 lawsuit to block that company's proposed acquisition, Drew Marine Group. Next, Michael Perry is partner in the antitrust and competition practice at Baker Botts, where he counsels clients in merger and non-merger antitrust investigations before the FTC and DOJ, and in complex private and government antitrust litigation. Michael joined Baker Botts after serving as counsel to the director of the Federal Trade Commission's Bureau of Competition from 2015 to 2016. In that role, he was directly involved in many of the agency's most important antitrust enforcement actions, played an integral role in the FTC's challenge to the proposed Cisco-U.S. Foods merger, as well as other high-profile cases, including FTC v. Actavis, FTC v. Cephalon, FTC v. Advocate Health, and FTC v. St. Luke's Health System. Great group of panelists today. Look, I think at the outset, one of the reasons this situation is so interesting is that it's really, really unusual. And just to kind of rehash the facts, you've all been sitting here, so I won't spend too much time doing it. But so the deal's announced in April 2018. May of this year, FCC Chairman Ajit Pai said he would support the deal with conditions. In June, a group of state attorneys general sued to block it full stop. And then in July, DOJ filed a complaint against the deal, but simultaneously announced a settlement that included conditions that went quite a bit beyond what the FCC had demanded. That settlement has not won buy-in from the states, who've continued their litigation to block the deal. Trial is set to kick off on that December 9th up in the Southern District of New York. So obviously unusual to have the states and federal government diverge to the point where the states are suing to block a merger, where DOJ is taking a settlement, not a ton of precedent for people to point to. Nonetheless, I know there's a view among some people that the judge may be inclined to defer to DOJ and FCC on the remedy, just given that they're the federal expert agencies in antitrust and telecom, respectively. So just to kick things off, and Michael, I'll start with you, and Corey, bring you in. In assessing litigation outcomes, how meaningful is DOJ and FCC sign-off here? Does it give the defendants a key advantage or maybe even silver bullet in the sense that the judge may be inclined to defer the federal agencies, or is FCC and DOJ endorsement maybe less important than some people might think?
Sure. So before I turn to that, I want to thank the Capitol Forum for inviting me to be here today. It's been a great program, and I'm happy to be part of it. You know, the government in horizontal merger challenges typically has a number of advantages going into court, and you know, the number one I think we're going to get to is the structural presumption, and we've already talked about that to some extent. I would say number two is that the plaintiff is the government. Most judges tend to be institutionalists, and although they put the government to its burden, they recognize that it's not a private dispute, and there's an inference generally that we wouldn't be here if there wasn't at least some there to the plaintiff's theory in that particular case. So I think the primary impact here is that it's not so easy to say one side is the government and one side is not, because you have some governments that are challenging this transaction, you have others that have settled, and others that aren't taking action. So it complicates to some degree the inference that I think judges either explicitly or implicitly make when the government is a plaintiff in a case like this, and suggest that reasonable minds can disagree as to the right outcome here. When I was at the FTC, we always preferred going to court on a 5-0 bipartisan vote than on a 3-2 party line vote, and I think largely for that reason.
Corey, what do you think?
So I generally agree. To me, this case boils down to this question. Will the judge defer to the federal agencies who looked at this and found that it was going to be a package that remedied the harm they were trying to fix, or will they defer to the states who are bringing the case? And when I counsel clients, sort of like Michael talked about, I can never tell them they have more than a 50% chance of winning a merger trial, because usually in a horizontal merger case, there is the presumption that the government is going to have, and there's also the deference that the government is going to have with the judge. And here, we just don't know which way that deference is going to go, but we do still have the presumption, we do still have a complaint by the Justice Department, as well as the states. So we do know that there will be a presumption. Well, I assume the judge will ultimately find there's a presumption. So there's definitely going to still be some deference to the states because of the presumption. And the key question is whether the judge will then give the deference to DOJ and FCC.
That makes sense. So another thing that's interesting, and I think what you both just spoke to gets to it, which is who's the government here. But like these trials aren't typically particularly political or at least partisan, I would think. But I think there's also a question about whether this one might break that mold. The FCC voted 3-2 along party lines to approve the Trump administration. DOJ signed off on the deal. Number of Democratic senators have come out against the deal, including quite a few of the leading candidates for the presidential nomination. 15 of the 16 state AGs, 15 of the 16 AGs suing are Democrats, with Texas the one outlier. So there's a real partisan split here that I couldn't really point to another example of this. Our good precedent for this, Judge Victor Marrero, who's hearing case up in the Southern District, is, I would note, a Clinton appointee. Question is, do you see politics playing a role? And Corey, I'll bring you in. I'm defining politics as Marrero maybe being a bit more skeptical of the FCC and DOJ decisions, just given that they're coming from the Trump administration. The more extreme version is, look, the Republicans think this deal is good, the Democrats think this deal is bad, and maybe that influences how the judge views things. Is it not unreasonable to think that politics could play a role in what the judge does here?
I don't think it's unreasonable, but I actually don't think it's going to play a role. I think it would be a mistake on the part of the plaintiffs to try to play up that this is the Trump administration, because you don't know how the judge will react to that. You know, typically when you think about Article III judges, you focus on whether they were nominated by a Republican or a Democrat, not because that is going to always influence their decisions, but because of the philosophy that you anticipate they'll bring to the trial. And so as a Democrat appointee, you think that he's going to be potentially a little more plaintiff-friendly, a little less business-friendly. So that dynamic may still play true, and that would then, put one to the side of the states. But the idea that this is Democratic states versus Trump, to me, that is something that the press has done a lot with, but is not something that the judge is going to care much about.
What do you think?
Well, it's an interesting question. We actually represented a company that had a deal before the FTC that was also being investigated by the state of California very early in the Trump administration. And we ended up getting the deal through the FTC unconditionally. The FTC didn't take any action or require any kind of commitments. And then the state of California sued to block the transaction. And when we were litigating that case, when we, in our, I guess it was opposition brief to the motion for a preliminary injunction, one of many arguments that didn't have a lot of emphasis was exactly the point that your last question went to, which is, the FTC is an expert agency. They investigated this for a year, found it didn't require any remedy. We included that, and maybe it was a paragraph or two. When we got the reply brief from the state of California, page 1 and probably 5 to 10 pages of what was a 15-page brief it was the Trump administration that cleared this deal. That's exactly why we need to step in here. And a number of state attorneys general have been very vocal about that position, that in their view, the administration has not been as aggressive as they would want to be with antitrust enforcement. So I agree with Corey that I don't see that politics influencing the case, but you can draw your own conclusions about to what extent the case influences politics in some of these local states. The other thing I'd point out is, and this is sort of one of the unique features about state antitrust enforcement versus federal antitrust enforcement, is that each state may have different interests and different goals, may have objectives that are not exactly, or sort of multiple objectives at the same time, and you're seeing a number of states enter into settlements that, in the view of that particular attorney general, are in the best interest of that particular state. So that, I don't know if that's politics, but it is part of the interesting dynamics here, where you have 50 different state enforcers that could be involved in some way.
So if I can just add to that, I think that's a fantastic point. And you can imagine, even if California and New York wanted to cover 15 pages of a reply brief with, this is the Trump administration, they did convince Texas to join. And that is going to be something that they have to, it would be a big loss to them, I think, if Texas now pulled out. And so they have to be very careful about, drafting it that way, and they probably won't get buy-in from Texas if they do draft it that way.
That's a good point. One of the downsides to being able to say you're a bipartisan group of AGs. So the politics are interesting here, but like you both said, I think unpredictable, and we just don't know. On the fix, so DOJ extracted a pretty significant settlement here, which basically seeks to bring in Dish as the new number 4 in the wireless market to replace Sprint, which I think means there are two separate issues at trial. A, whether the underlying transaction, T-Mobile Sprint, violates Section 7, and then B, whether the deal is modified by the Dish fix still is unlawful. If you're the plaintiffs, how do you approach this? If you're the states, do you spend a lot of time on the original transaction and only hit the fix as kind of an afterthought? Do you kind of split your attention and go 50-50, or do you really devote most of your time to attacking the Dish fix because that's what got things over the finish line at DOJ? Corey, I'll let you kick it off. How do you allocate your time and resources on these two questions?
Yeah, it's a great question. You have to prove your case. So you have to devote some time to showing that the merger is anti-competitive. I don't think that's that hard because, again, you have a DOJ complaint. You have FCC sort of saying it is. But you've got to prove your case. So you do have to spend time on that. But where you are litigating the fix, and I've litigated the fix, but never with the benefit of having DOJ have agreed with my fix, you have to also attack the fix. And here, where you have DOJ, FCC, and other states all saying that fix is enough, I think you've got to spend a good portion of the trial, so maybe 50-50 on how I'm thinking about it. The wrinkle for me is that the state complaint focuses on national market and local markets. But the DOJ complaint only focused on national markets. They didn't do what they did in AT&T T-Mobile and allege national and local markets. In fact, the state complaint looks much more like the DOJ complaint from AT&T T-Mobile than the DOJ complaint does. And so if I'm the states, I want to hit on the fact that we actually allege different markets. And the fix that you're talking about here is the fix DOJ approved to fix their complaint, which is about national markets. It's about 4-3 nationally. And I want to attack that too. But then I also say it has nothing to do with the local markets that I'm alleging. So when I prove to you that there's problems with these local markets, they don't have a fix that they have focused on these local markets. And that would be my strategy if I was the states.
That's a great point. Michael?
So Corey's absolutely right. The defendants are rarely successful in litigating the fix, and when they are, I think they're successful in recharacterizing what the court is doing legally. So, if you go back to Professor Cuoco's discussion, and you think the case law on merger remedies is very favorable to the government, and says basically the remedy has to fully restore competition, and that's almost always an impossible standard. That's why you usually see consent orders negotiated and resolved at the agency level, and it's much more challenging at the in litigation, given that case law. One of the few cases I know where it's been successful is in the FTC's case against Arch Coal, and there's a fair bit in the decision about the judge's reasoning. But actually, a few years ago, Judge Bates was on the judicial panel at the ABA Antitrust Spring Forum, and he provided some insight as to how he viewed the case, and it was obvious that the parties in that case were successful in recasting the remedy, and instead of saying, okay, does this remedy fully address an otherwise anti-competitive transaction, he looked at it as, we need to look at the entire competitive analysis. Is this transaction anti-competitive, assuming the fix is in place? It is signed up. That is the reality. So let's not look at the original deal, because that's not the deal in front of me. And so I think that's likely what the defendants will do here, and you start to see some of the indications that that's the case because, they're emphasizing, not only the DOJ commitment, but the binding FCC commitments as well, the FCC's role. And so I think if defendants are successful in recharacterizing this as, we're not saying this remedies this, we're saying this is part of the prima facie case that the government will have to make, that's where I think it can have greater inroads.
Right. And actually, that leads me pretty well into my next question. This same question, but thinking about it from the defendant's perspective. So, like, how much time, if you're the defendants, do you go around saying, look, the original deal is pro-competitive, it's great, and then hit Dish at the end? Or do you spend a lot of time on Dish? Because if you say the original deal is an anti-competitive, fine, but then you're disagreeing with not only the states, but also DOJ, which said the deal is originally structured, violated Section 7. But the fix, and we'll get to this in a bit, has some question marks, and we can refer to Professor Koka's remarks as well. And as you point out, litigating the fix, typically not successful. So it seems like you're kind of between a rock and a hard place. You say the original deal is fine, great, but then you don't have DOJ buy-in for that. Then you spend a lot of time on the fix, which DOJ signed off on. Well, the fix is tough, A, on the merits, B, on the case law. If you're the defendants, how do you kind of shoot that gap? And Michael, I'll kick it over to you because you kind of were on that.
Yeah, you clearly have to do both. And I think the way that I've seen that done successfully is to say, look, we fundamentally disagree with the government's entire theory. That bears no reality, it bears no bearing resemblance to actual commercial realities today or into the future. You see those types of narratives as part of what's been put forward in this case, like you do in any merger challenge. And then I think you draw a line in the sand and say, look, let's suppose for the moment that the government was right and this has some theory. If that's the case, then this remedy more than adequately addresses that. I think that's a tough line to walk, but one they'll have to do. I think the most important thing, as I mentioned before, is to try to recast the remedy as not a remedy, but just something that is part of the effectively the pre-merger status quo that the judge is evaluating.
We'll keep on this, but I'll ask it slightly differently. And this is kind of more on the merits of the Dish fix, and we'll just talk about that a bit. And obviously, Professor Koka spoke at length. But so Dish is going to acquire Sprint's Boost and Virgin Mobile prepaid brands, about 9 million subscribers. They have an option to buy Sprint's 800 megahertz spectrum, as well as decommissioned cell sites and retail stores. Dish does not have a wireless network, which is actually pretty important to competing in this industry. And the remedy addresses that by providing for a 7-year MVNO agreement during which Dish can basically lease capacity from and operate on T-Mobile's network. And this is because it's going to take Dish, best case scenario, 4 years or so to build out a wireless network that covers most of the country. So look, between now and 2023, it can compete on network capacity, quality, et cetera. It's a complicated fix, and it raises some very real questions around ongoing entanglements, other factors. But you also have DOJ saying the fix actually improves status quo, and you have the FCC actively monitoring it. So it seems to me if you're defendants, you have this one really good thing, which is DOJ and FCC endorsement of the fix, and you have this one really bad thing, and I guess it's probably two really bad things, which is A, the fix is really complicated and has some holes, and B, courts have historically been really skeptical of litigated fixes. So Corey, how do you see this playing out? How do you see the plaintiffs attacking this? How do you see the defendants defending it? And what is the judge, how is the judge evaluating this question?
Yeah, so I think the defendants just wrap themselves in the cloak of the DOJ, FCC, and other states' approvals. You've got not just got the settlements that we talk about from DOJ and FCC. You've got the various state settlements that have occurred with the public utility commissions. You have the offers that have also been made now by T-Mobile in California, and then the large promise of what will come to consumers from this deal. I think you just wrap yourself in that and you keep hammering it because that's your win. I mean, I do think and agree with Michael that you have to first defend the transaction on its own. But I think the strategy there is more to put questions in Judge Marrero's mind about how significant are the anti-competitive effects. Because if they're not that significant, then I start to think about the efficiencies, and they're significant. And even if I don't credit them all, then that's something. And then I've got this fix. So if I'm the defendants, that's what I'm trying to do. I'm trying to get him to a point where even if he rules against me on the original transaction, which I expect from day one, I've got these efficiencies and I've got this fix, and that's why this deal goes through. Now, as I said earlier, on the plaintiff's side, I think the counter is that fix has nothing to do with the local markets that we've been focused on. That fix goes against everything that the DOJ has ever published about what a fix is supposed to look like. And I've got quote after quote after quote about not having entanglement, not having behavioral remedies, and I hammer it that way.
That makes sense. Michael, same question. And look, you mentioned Arch Coal, and it's like Arch Coal was a litigated fix that was successful. Arch Coal involved a coal mine. This is, I don't think it's an overstatement to say, like an entire reorganization of the entire U.S. wireless market through this fix with a really significant ongoing entanglement, et cetera. How do you defend this if you're the defendants?
So I think if you're defendants, you pitch this fix as part of fundamental transformation in the industry and say, look, the government's theory, the government's market definition, the harm alleged is all about the status quo or the past, and the whole industry is going through a transformation. There'll be the companies that are successful today may or may not be successful in the future. This transaction on its face is about making T-Mobile and Sprint together successful in that future world where they may not be today. And the FCC and DOJ fix is about creating a fourth competitor that may be successful in the future. And you really make it about the government's case misconstrues competitive realities, particularly on a forward-looking basis in this deal, and make that the frame through which you put on the defense of the fix, less as a remedy, but more of this is further evidence of the government's got it wrong in terms of how they're basically viewing the market. I mean, you heard Rob position it as this isn't a 4-3, this is a 2-3 or a 2-4. That's, I think, what they will do.
Right. That brings us really well into market definition and structural presumptions. So look, I think market definition is really tough for defendants here. I think most people have a pretty strong intuitive sense there are 4 firms in this market. Not only that, but I mean, DOJ's defined these exact markets in its complaint. Now, national, not local, but we all kind of, I won't say we all, a lot of people would agree that this product market is pretty defensible, and the states are going to be able to create a structural presumption of harm in those markets. Look, when you talk to people who think the states are in a good position here, a lot of it comes back to this. Like product market, geographic market, market concentration numbers aren't particularly controversial, and the states are going to be able to establish a pretty strong structural presumption, especially if we get local markets, and then we're talking HHIs that are absolutely through the roof. When the government establishes a structural presumption, it almost always wins, and there may be a few counterexamples of that, maybe just one. So the defendants do have a few arguments, and one is that the state's market concentration numbers are skewed because they exclude MVNOs. Also, this national versus local market distinction. And look, the HHIs are still a big problem in the national market, but they're less bad than they are when you bring in local markets. But at the end of the day, I think most people would agree it's a real uphill climb for defendants to prevent the states from establishing a presumption. So if we accept for the purposes of this question that what I've just said is accurate, if you're the defendants, how do you approach this? Do you have to spend a lot of time on market definition, market concentration, just because the structural presumption is so crucial to the state's case? Or is it better to just tacitly concede it and say, look, we disagree, but we're going to go big on efficiencies, flailing firm, the fix, some of these rebuttal arguments? Michael, how do you see the defendants approaching this question?
So I think, as we started, or as I started the discussion, I mentioned that I think the government's number one advantage in horizontal merger challenges is the structural presumption, and I really think that's the case. So I think you, as defendants, you need to do something to go after that and to take away what is a very easy, clear path for the judge to write a decision in joining the merger. But I think there are options beyond just attacking market definition. I think defendants will do that. I don't think that they will, tacitly or otherwise concede those points. But I think they'll look for other ways to combat the government's prima facie case and to really try to get the judge not to get to the point where he says, well, I'm going to shift the burden and say defendants now need to show that notwithstanding this presumption, it's a pro-competitive deal. And I think they could potentially do that a couple of ways. One, we talked about, the fix and the way that can be done. Another way, and this was alluded to in Rob's presentation in the last panel, is to make what I would call sort of a general dynamics argument, is that, there's a lot of discussion about, is there a failing firm defense here? And there absolutely, defendants will not describe it as a failing firm defense, but the similar facts, they can say, look, if the current shares in the current wireless markets aren't reflective of competitive realities in the future, and they may have a successful argument that you need to predict forward, and that Sprint is not going to be as successful going forward, and in particular, neither of the merging parties have on their own the infrastructure needed to be a competitor in the future 5G world. I mean, that's I think the way you take the arguments that you're hearing today and put those in a frame that allows the defendants to say the government hasn't met its initial burden of establishing a rebuttal presumption under the case law.
Right. Corey, what do you think?
I agree with everything Michael said. The reality is, to win a merger case as defendant, you either have to convince the judge that, usually it's DOJ or FTC, but in this case the states, has alleged the wrong market. And if you can do that, then they don't have a presumption and you basically win. And their burden of proof is really to show that their market is the right market, and then they get the presumption. So I think the defendants absolutely will go after it. I don't think in this case that they will go after it maybe as hard as I have in some of my cases, because I don't think they have as strong arguments, and I've had other cases where we didn't go after it that hard because we knew there just wasn't that much argument. But they can go after the things that Michael was talking about. They can even try to argue, some of what we heard on the last panel is that Sprint isn't actually in the national market. So, you can nibble around those market shares in different ways, even if you're not head-on attacking a national market. That'll be a little bit harder, I think, on some of the local markets where they're direct head-to-head competitors, and there may not even be AT&T and Verizon with the same level of competition.
Yeah, that makes sense. So I think to kind of add on to that, so look, assuming the states establish a structural presumption, and I think they very likely will, that the deal's anti-competitive, maybe you get two efficiencies as a rebuttal argument. And look, it's a big argument for the defendants. And obviously an efficiencies defense has, I believe, never carried the day in court, certainly when the government's established a presumption. And not only that, but DOJ's complaint says efficiencies won't offset the deal's anti-competitive effects. So look, from day one, efficiencies has been so core to the company's arguments. If this deal is perhaps pro-competitive, it's gotta be because of the efficiencies. So you have the situation where the best argument for the deal on the merits is probably efficiencies. Also this knowledge that courts are typically really, really skeptical of these efficiencies arguments. If you're the defendants here, like, how do you do this? What is the pathway to becoming effectively the first defendants really to prevail on an efficiencies defense? How do you put it on? Corey, can you successfully put this on?
So I don't know if they can successfully do it, but I think, yeah, you go after efficiencies hard, and we saw with Anthem Cigna doing that a couple years ago. Certain judges, that's not going to fly, and DOJ did stay true to itself in finding that the efficiencies didn't outweigh the anti-competitive effects that they found, so you don't get the benefit from them on that. But ultimately, it's I think the efficiencies combined with the fix that is your argument. So even if they do win, I don't think we'll get to, as defense lawyers, finally say, oh, look, a federal judge approved a merger saying the efficiencies outweigh the effects, which would be wonderful if it happened that way, but I don't think if they win that it's going to be purely on the efficiencies. I think it'll largely be on the fix. So I do want to note, it's obviously not just the efficiencies. I mean, once the presumption is established, defendants will still go after whether there are anti-competitive effects, even if you assume the presumption. Yes, 4-3 is often viewed as bad, but they may argue that there will be robust competition going forward between the big three. Dish will be a certain strength, or other MVNOs there will be other arguments that they bring in, and then the flailing firm of Sprint and whether they would even be competitive in the future. So there are other ways to go after it, even if you've lost the presumption.
Right. Michael, efficiencies.
Yeah, I agree. Posed as an efficiencies defense, it's just really difficult to prevail under the law. I mean, the Ninth Circuit decision in St. Luke's, for example, where the district court had credited the efficiencies, and but reluctantly ruled in the government's favor. The Ninth Circuit says we don't even really know what this efficiencies defense is, but in any event, it's not sufficient here. And other courts have generally been similarly dismissive. So I think that that said, I think the efficiencies here are a really important part of the case in potentially two ways. One is, when you're a defendant in a case like this, it's not sufficient, but one of the necessary things you need to do to win is have a counter narrative as to why you're doing the deal. And here, you really want to emphasize we're doing this to compete in this 5G world, and it's been recognized by the government and all these commentators. It has nothing to do with taking out competition, and you want to establish a counter narrative to what the government's putting forward, so that you persuade the judge to sort of read the law and the facts in your favor. The second thing that I think that you can potentially do, and I think Corey alluded to this, is basically recast the efficiencies argument and get the judge to evaluate them not with, at the end of the merger guidelines like they are, tucked away with entry, but instead as part of the competitive effects analysis and say, look, ultimately, what you need to do, Judge, is decide, is this going to be good or bad for consumers? And this deal is going to enable us to do, X, Y, and Z that's going to be good for competition, good for consumers. And so you should really consider that as part of, your core analysis of whether the deal is anti-competitive or not. And that's, defendants that have been successful, I think that in taking advantage of efficiencies, it's as part of the competitive effects analysis as opposed to this standalone thing that gets weighed at the end.
Right. This kind of story for the deal, and I guess the story against the deal, is interesting, just in the sense, like, we have this idea that storytelling is really important in merger challenges and merger litigation, and T-Mobile and Sprint are doing the deal to create all these efficiencies in 5G and to better compete with AT&T and Verizon. That's the motive or rationale behind the deal. I think the states are arguing, a couple different things, but it seems to be this idea that Deutsche Telekom, who's T-Mobile's German controlling shareholder, has always wanted to consolidate this market. It's a long-term plan to go from 4 to 3, rationalize capacity, rationalize pricing, all this kind of stuff. Basically, there's these competing stories, competing narratives that I guess the sides are going to present. My question for you both is, how important are these, stories or broad themes in these merger litigations? Because I read these decisions, merger litigation decisions, and it's typically like, here's the product market, here's the geographical market, the deal's bad, the deal's good, whatever. It tends to be less into these broad themes of like, here's the intent behind the deal, here's why they're doing it. You see what I'm saying? And I guess my question is, like, we have these broad themes, these broad stories. Do these actually matter when a judge is thinking about his decision? Or are these stories kind of secondary, and it's a nice way to frame your story, but they're not really moving the judge one way or the other? Maybe not incredibly well put there, but how important are these stories, these broad themes, and putting these cases on? And Corey, I'll start with you.
Sure, I think they're really important. I agree with you. The judges' decisions rarely tell the story. That's because in antitrust merger decisions, judges are cribbing from the statements of fact and conclusions of law that get submitted after the trial. And those documents are usually 150 pages long, and they're just pulling them out. And so the decisions end up being 90 to 120 pages as well. And they're not telling a story because the judge is trying to get this done in a quick time frame and doesn't really have time to write the decision like they usually do. That said, I think if you're going to convince the judge to go your way, whether you're plaintiffs or defendants, you have to have the story, and it has to be backed by your evidence. It has to be backed by your witnesses. It has to be backed by your documents. And where you fail is you tell a story that doesn't have any support. And if both sides do their jobs, which I'm guessing will happen here, you will have two stories that are both backed by documents and witnesses, and so then the judge just has to balance what, in this case, he thinks is the right way to go.
So, Mike, I'll give you that same question, but just to add a bit to it, and maybe this should have been the first question. How is merger litigation won or lost? And Corey obviously alluded to this. Like, what do these cases typically rise and fall on? Merger litigation is unusual, and I think you would both recognize that, just in the sense that we're trying to kind of predict the future, whereas most of these judges are looking at stuff that happened in the past and did this violate the law or not. So they're unusual, they're economics heavy, it's generalist federal judges. It's a weird, I don't call it weird, it's an unusual kind of situation. So how are these cases won or lost? Economic experts, witness credibility, docs, all three stories. I realize it's probably an overly broad question, but how kind of would you explain to a layperson or a non-layperson? What do these ultimately rise and fall on?
So first, I completely agree with Corey that the story and the overall narrative is not only critical. I think it is the issue. I mean, that is why you have trials. Is to, you know, there's almost always a view of the facts that can go one way, a view of the facts that can go the other way. There's law that supports one side, law supports the other side. You always have very well qualified experts, reaching diametrically opposed conclusions. And so, that's the art and excitement of trial, is that you put those two cases side by side, and which one does the judge or a jury fundamentally believe? And that's why those intangible factors in the story and the overall narrative are critical. And I think when you look at, and I think when you read, especially judicial opinions coming out of a case, you're not getting the full story. It's exactly like Corey said. Every issue up and down the line are always closer, and there's always nuances and ambiguity that, when the judge is writing an opinion, trying to insulate it from appellate review, lines it up and sort of sides with one side most of the time. And so it doesn't tell the complete picture, the complete factual picture. And so, how are merger trials won and lost? It's all of those things. And really, it's each of the key pieces of evidence. How closely do they fit the story? Are the company's internal documents consistent with what the reasons why they're saying they're doing the deal on balance, or what the government says is the reason they're doing the deal? How consistent is economic experts' one theory of harm versus the other economic experts' analyses? How closely do those fit the documents and the testimony? How credible is the testimony? And so that's why, at the end of the day, these are very detailed trials. They really get into the nuances of the technology and the economics, and I think most judges, even though most don't have an antitrust background, really roll up their sleeves and dig into it. But at the end of the day, it's really a human factor of which side do I believe within the constraints of the case law, and that's the unpredictable nature of trials.
I would just, as an example, I mean, we have certainly had trials where I think both sides agreed that the evidence came out on one side, but the judge wrote the decision because they were persuaded by the story of the other side for them, and then used evidence, cherry-picked from the record that wasn't supported elsewhere to write their decision in a way that was sort of unassailable on appeal.
So, big question here, and you have both agreed on a lot. I don't know if you'll agree on this. Look, you're both lawyers. I know the instinct is to answer with, it depends, but I'm going to ask anyway. Push comes to shove, and with the caveat that we're not privy to all the facts, and we don't know how the evidence is going to come in a trial. Who do you think wins? Why? And I'll let either you go first.
Sure. So I started by saying that you can't really honestly tell a client, if you're a defendant, that they have a greater than 50% chance of winning against the government in trial. This is the rare case where I think you could say, I've got a 50% chance of beating the government. There are several favorable factors. The fix is obviously huge. To me, it's a big deal they're not in D.C. D.C. judges, Arch Cole aside, tend to be very deferential to the government, and some of the more successful merger trials have been outside of D.C. So you've got some very favorable facts for the defendants, and I wish I was their lawyer on this. That said, if the states end up taking this to trial and not settling out, I think the states win.
I have no idea. That's a non-lawyerly way to
That was
provide
really
a
good. Yeah,
lawyerly
yeah.
response. So.
Okay. That works. I have a couple more questions I could ask, but I will turn it over to the audience in case there are any questions that people would like to ask the panel.
Yes, I just had a question on the story. So, you guys both mentioned how important the story is, but then when you were talking about the kind of political backdrop, that it doesn't matter so much. But isn't the political backdrop part of the story? The part of how this is unprecedented for the DOJ and FCC to approve? I mean, you just read, the Commissioner Rosenworcel's statement, and, that's just a damning perspective of how this wouldn't fly under a normal kind of circumstance, and doesn't that kind of depict the story of how this just isn't an adequate remedy?
I'll start. Yes, I think that's the story. I don't think it's a political story. I don't think it's, three Trump FCC commissioners and folks appointed by Trump at the Department of Justice let this go through. I think the story is this is the federal government not doing what they have always said that they should do to protect the citizens of our various states. They've cobbled together a fix that doesn't even take effect for several years, which goes entirely against their own guidelines. They've allowed behavioral remedies that goes entirely against their own guidelines. I think that is absolutely the story, but I don't think it's Trump. I don't think it will be politicized in that way. I don't think Texas would be involved if it was. And I think a senior judge like this one would be a little repulsed if it did become a political trial. And so I think it could backfire if the plaintiffs, the states, did start to say this is all about Trump and his administration not doing what they're supposed to do. They can just say this is the federal government not doing what it needs to do to protect the citizens of our great states. My view.
And I want to clarify, too, that I think when we were speaking earlier about the story, or at least what I was referring to, was not, what reporters are writing about, what, gets entire day, half-day long sessions about an antitrust case convened, what's on front page news, but what is the antitrust story? And what I mean by that is, if you haven't ever been to any trial, but particularly an antitrust trial, they are dense, in the weeds, multi-day, if not multi-week, if not multi-month, very slow-moving, processes. And so the story there is, what is the lens through which you're going to view this very voluminous, very technical evidence? And ultimately, is it consistent with the view that this deal is good for consumers or bad for consumers? So I agree with where Corey started, which is, there are a lot of atmospherics here and political issues and things that make this case interesting to observers. I don't think those are going to be what drives. That's not the story, at least I'm referring to. I'm talking about whose view of the sort of fundamental nature of the transaction will prevail, and that's what I think will get litigated in court.
How do you guys think the Honey Act process will impact or not impact this trial? So if I guess I'll just throw out there that the judge who's overseeing that is a Republican-appointed, Trump-appointed judge, and if you got to the point where, let's say, he came out and said, yes, I approve this fix, I understand it's under a different standard than what Judge Morero is looking at for this trial, but does it make it harder or easier for the judge to come to a different conclusion on the same question effectively?
So I'm going to reveal myself as quite the antitrust nerd, but I actually wrote my undergraduate thesis in economics on the Tunney Act, and I'm pretty sure that that was the last time that I had ever really thought about it, other than going through the motions of actually going through the Tunney Act review until this past year, when there was a real live, exciting Tunney Act proceeding. So I don't view it as likely to have a major impact. It rarely does. So we'll see if that becomes a trend, but I don't see it playing a major factor.
Yeah, and I've thought about this a good bit, because as I think about how I would handle it as a defense lawyer, if I've got another federal judge that's already approved my fix as fixing things, how much do I argue that in front of Marrero? Um, I, I think we'll see a little bit of it, at least in briefing and such, but I don't think we'll see a ton of it, in part because of those local markets that I mentioned. And then, ultimately, what's going to be approved in the Tunney Act proceeding is only covering some of the same alleged markets.
Michael, you talked about one of the strategies for the defense would be to present the deal alongside the fix as the deal in front of the courts. Given that the fix is so complex, Professor Boca talked about as a jigsaw puzzle, it's probably like three-dimensional, some Jenga thing. Would you be concerned about that backfiring if plaintiffs were to argue that all the elements of the fix are interdependent, they're all conditional upon each other, and what is the probability that all of these are going to be successful? Like, are they segregatable, I guess, is the question.
I think you make it part of the broader narrative and say, look, we shouldn't be focused on the competition today and market shares today and technology today. We're all working towards a new technological standard where there'll be different winners and losers than there are today, and different companies have different advantages and disadvantages. So you can poke holes in the capabilities and assets that Dish will have with the remedy, in the same way that there's no guarantee that anybody that is successful today will be successful in the future, given how rapidly the industry is changing. But I think you say that the point you make is that market shares today, however you define the market, are not what you should be looking at in evaluating whether this transaction is going to be anti-competitive or pro-competitive, is going to hurt or harm consumers. You need to look at all the various factors, the way that the industry is changing, the binding commitments that are in the remedy, as well as the efficiencies in the transaction. So it's you're trying to recast change the playing field.
But I guess, is the complexity of the fix itself, does that make that argument harder than you were saying, divestiture of a coal plant? Does that make it less credible?
Well, so Professor Cuoca compared, the prototypical divestiture where it's a standalone business, it's all of one side's business. I think if that were the remedy on the table, then we wouldn't be here. And so, that sometimes, and this happens much more often in agency practice than in merger litigation, where, you have a fact pattern where, you have a remedy on the table. Maybe it doesn't meet all of the standards. There may not be 100% confidence it's going to restore competition. You have efficiencies. You have some reason to be concerned about competitive harm. You have some reasons to think that the transaction is going to be good. And so when agencies bless what look like creative remedies, often that's because they're ultimately persuaded that maybe they don't love the deal, but the alternative, that what's on the table is better than the alternative. And there isn't yet a settlement with all of the states in this transaction, but ultimately some of the states and the DOJ and the FCC concluded that what was on the table was better than the alternative.
And I think there's no doubt it makes it harder. They will be able to argue that it's behavioral, right? And then there's a reason that DOJ usually doesn't accept behavioral. They will be able to make the argument that this doesn't, in the short term, fix any anti-competitive effects. And then they will be able to argue, to your point, that we don't even know in this forward-looking exercise if they'll be able to hit the metrics that we have lined up, or have the incentives in 5 to 6 years to hit the same metrics that we've lined up in this deal. So I think that is going to create some serious complexity for the defendants to weed through.
Real quick question, Jonathan Make from Communications Daily. I'm just curious if either or both of you are going to go up and watch any part of the trial, if you are looking for any, I guess it wouldn't be binding, but any precedent that might come out of this, given it's somewhat unusual with, the government being on both sides, and also if you can just, I guess, characterize if your firms, are not involved with the deal or the court case and such.
And so we're not involved with the deal or the court case. I'd love to find the time to go up there and watch, but that won't happen. We'll be reading about it, though. I mean, for a merger litigator, I'm always hopeful that good precedent will come out of this. And there is a chance that the judge rules for the defendants and gives more credit to efficiencies than other judges has. There's a chance the judge, accepts this fix. And, it's interesting for me to think about going before DOJ and FTC and proposing in the future fixes that look like this. If this gets shot down, I have no argument about the precedential value. But if this gets accepted, it puts DOJ in particular, and the FTC a little bit, in a really interesting position when I go argue that I've got a fix that does the things that this one does. Because you'll have a judge having approved it, not just them having done it without a judge's approval. So while I think the states probably have the better arguments, I'll be watching closely to see if I've got future arguments that I get to use against DOJ and FTC. And the states if they keep enforcing.
Yeah, I'll just be reading communications daily and get my regular updates. So.
Is there any significance to this being in the Second Circuit rather than DC Circuit, case law-wise? I'm assuming no, but does that change anything?
I don't know.
Yeah, I assume the answer is no. It's probably no, right?
It is an interesting question. I mean, the D.C. Circuit in particular is very government-friendly on the case law. I remember when we were getting ready to go litigate St. Luke's, which is in the Ninth Circuit, actually in the very few litigated merger cases in the Ninth Circuit, I think the majority of them had gone for defendants. Corey, I think, won one of them on behalf of defendants. So the law wasn't great. But ultimately, the judge, relied on the D.C. Circuit cases because that's the bulk of the cases anyway. So it probably doesn't have much of an impact. But, hard to say.
Yeah. Any last-minute questions from the audience? Dane? 3 minutes early. Thanks, guys.
Well,